All right, the jurors are in place in the jury room, Mr. Bailiff.
Yes, Your Honor.
Very good.
So
Bring me the jurors.
Bring the jury.
You have done absolutely nothing wrong.
Good for you, Justice Toal.
Not any of you. You didn't ask to serve, but you served and did your duty. This was an unusually difficult trial because of its length. 6 weeks is almost unheard of in South Carolina as the length of a case.
Idaho says, hold my beer.
It was difficult because of the intense publicity and public interest in the case. It was difficult because of the complexity of testimony and exhibits in the case. And you acquitted yourself honorably. So this question today is not about anything you did wrong. Please be assured of that. I respect you and I respect your service. Today, I'm going to ask you to do something that's difficult. This case is unique. Most of the time, if there's some issue about improper conduct or
the entire prosecution team is there, including the state attorney general, Alan
puts
Wilson.
Questions to the juror and perhaps to the person who may have made a improper comment, and then you go on to verdict. Mm-hmm. Today, I ask you to focus your attention. What is that?
Yeah, what is that?
What is that noise?
Justice Toal looks concerned. I'm concerned. There is a clatter in the courtroom.
Is that the sound system doing that?
I believe it's the court sound system.
This is the funkiest sound system in the world, so you just have to keep up with it. I've had trouble in every case I've ever tried with the sound system. So, jurors, if something happens and the sound system goes haywire, we'll stop for a minute until it stops.
Thank you, Your Honor.
As I was saying, I want you to focus your attention as you answer the questions
Today's
I'm going to ask you.
show.
On your 6 weeks of experience as a juror in this case, and on the point in the trial where the judge charged you, and on your verdict as you rendered it on March the 2nd, 2023. Bring me Juror Z.
Poot's bringing us the tea.
Yes.
One of the individuals sitting in the jury box called this the next jury liar publicly. I'd ask that that be Mr. Bland and his partner not sit behind her or near her while she's testifying.
I object. Well,
Your Honor, I object to him speaking.
One moment. We're not going to have a big colloquy like this. Keep your seat for a moment, Mr. Harpoot.
Yes, Your Honor.
Mr. Bland, you do the same. Mr. Bender, is there a seat over next to you?
There is.
Mr. Bland, will you go over
sit
and
next
sit
to
next to
Mr. Bender,
please? Thank you.
Thank you, Your Honor.
Bring me Juror Z.
Today is going to be crazy, you guys. It's already crazy.
Step over here to the clerk and she will administer the oath.
And we are starting with juror testimony.
Do you swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
The court's only going to ask those 3 questions. That's it.
I will ask you some questions, and there are no right or wrong answers. The truth is what I seek, and that is the truth of what you experienced in relation to these questions at the State versus Murdaugh trial. You rendered a verdict on March the 2nd, 2023. That verdict was read in open court by the foreperson of the jury. And then the court said this: Madam Forelady and members of the jury, if that is your verdict of each and every juror, let it be known by raising your hand. The transcript then indicates that the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? and each juror answered yes. Was that an accurate statement about your verdict at that time?
Yes, ma'am.
Wow, that took a minute.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Yes, ma'am.
If yes, what did Ms. Hill say?
Yeah. What the fuck did Miss Hill say?
To watch his actions.
To watch his actions? What else?
If anything.
To watch him closely.
To watch him closely. Anything else you remember?
Ma'am.
There is, but I can't remember.
Okay, that's fine. Was your verdict on March the 2nd, 2023
Oh boy.
in any way with any influenced in any way with any communications by the clerk of court, Becky Hill, in this case? Want me to
Yes,
read it
ma'am.
again?
What?
Please.
All right.
That is where I screamed so loud that I scared the crap out of my dog Frodo, and he ran into the other side of the house, because I don't think I've ever screamed like that actually in my entire life. I couldn't even imitate it.
Was your verdict
No, she said yes.
influenced in any way by the communications
She said yes.
of the clerk of court in this case?
Yes, ma'am.
And how was
Holy
it
shit.
influenced?
She said yes.
To me, it felt like she made it seem like he was already guilty.
Holy
And,
shit.
I understand that. That's the tenor of the remarks she made.
Ma'am, she
Did
said
that
yes.
affect your finding of guilty in this case?
Yes, ma'am.
Oh shit.
And this is the moment that I texted my friend to tell her that I was going to throw up. Shout out to I am not T-Pain. Love you, wifey.
Alec Murdaugh very well may get a new trial. I don't know if there's any option to not get a new trial.
Be at ease.
Holy shit. This is the second juror that they questioned. They questioned one juror on Friday.
My questions are submitted to the juror. Are there any reactions, further questions, and so forth? If there are,
I am
and you
not
would like
well.
to voice them, I can
That's
ask the juror to return to
wild.
the jury room.
They're gonna
Just tell me whether I need to do that.
they want to ask more questions, I'm sure.
All right, sir?
Oh my God. This juror said,
We need to put some things on the record.
All right. Take the juror up to the jury room, please.
I am stunned. Did this impact your verdict? That is what needed to be determined. I don't know how you get around a new trial on this. I don't know how you get around a new trial. The first person they questioned today was impacted. If one juror was impacted, he gets a new trial. Oh my God. Do you see the look on these prosecutors' faces? That's not what they were expecting either. Becky Hill.
Your Honor, in the
what the fuck did you do?
Affidavit that was given by this particular juror, paragraph 10 said, I have questions about Mr. Murdaugh's guilt, but I vote guilty because I felt pressured by the other jurors. We would request
no, you can't impeach
an inquiry
him.
as to that, which is how, when this motion was filed, she expressed the basis for her verdict, which obviously this answer is a little different now. So we would request a brief inquiry from the court as to that specific issue.
Wow.
Thank you, Your Honor.
Your Honor, as to two things. The first thing is, he is correct. She gave an affidavit. We would ask Your Honor to let her read her affidavit to refresh her memory.
No.
She said other things. They're very detailed in here. We'd ask you to, and let me hand up to the court, a copy of her affidavit.
These defense attorneys can feel it. They can feel the new trial at this point. I don't know if there's any unwinding that.
What I have here from Mr. Waters.
I'm going
for
to
the
hold your
record,
questions so we get to questions.
What I've been handed for the record is something, affidavit of juror, now referred to as Z. It was taken August the 14th, 2023. It was sworn before Holly Miller, paralegal for Mr. Harpootlian, and he would like for me to give that to the juror and ask her to read it and then ask her about it. I'm inclined to do that, but I want to hear from you first.
Your Honor, again, if they want to refresh the recollection, that's fine with the state, so we have no objection to that.
Very good. It will be done.
Your Honor, also we would ask that you not ask the question that that Mr. Waters asked you to ask, because it violates Rule 606B, which provides, upon an inquiry into the validity of a verdict or indictment, a juror may not testify to the effect of anything upon that or any other juror's mind or emotions.
What was the question he asked?
If you look at that affidavit,
It's paragraph 10, Your
Paragraph
Honor.
10.
It's in the very affidavit.
she said she was influenced. She was influenced by other jurors.
They are
I'm
fighting.
going to ask her about that. I'm going to give her the affidavit and then I'm going to question her about it.
Yep.
And we would, for the record, indicate that we object to that under 606B.
Your Honor, from our perspective, she's put an
And you're the
issue.
one that asked me to have her look at this affidavit, but you telling me I can't question about it? I deny that objection.
Your Honor, if it's something that's inadmissible, you should not ask her about it. And that's
Well, you want me to admit it and have her examined
No, I
on it.
want you to have her read it to refresh her memory.
You're quibbling, Mr. Harper.
You're quibbling.
About things that I'm not going to take time to quibble about. My ruling is, pursuant to your request, I am going to allow the juror to examine her affidavit, and then I'm going to question her about it. That's my ruling. Your objection is
Glad you're here
overruled.
early, guys. Glad you're here
For
early.
the record, I just want to know.
For the record, you're
This is the moment where Poot realizes he's fucked it all up, because he wanted to get I wanted to have something else made for the record involving this affidavit, and then he realizes that this question is in here that was asked of Juror Z, where she says that the other jurors pressured her and influenced her verdict, and that is totally allowed. So that's part of deliberation. It's okay for other jurors to influence other jurors' decisions and how they're going to vote. That's normal. It's part of the deliberation process, and he knows that, obviously, and he knows that this could very well completely ruin the impact of the previous statement made in court where she said that it was Becky Hill. But it's in this moment where he realizes he's fucked it up, and it's all over now, because he had he not made that request for the record and asked for her to read the affidavit and have her memory refreshed, this wouldn't be happening. The only reason this is coming in is because he wanted to have her read her affidavit to have the memory refreshed, but then it's only, like, there's no way around it then. Now that has to be, the affidavit has to be put on the record, and she has to be questioned about it. This changed the course, I think, of this entire hearing, and you can see it when he sits down here in a second. You can see that he knows he's just lost this.
Just for the record.
You noted 606. I hear you noted.
noted. Move
In
on.
no way waiving anything or opening any door by asking you to let her
That's
examine.
for a higher court than me to decide.
Well, I
Says
understand
the
that.
former
That's why I wanna make
justice
sure
of
when
the
they read this
Supreme Court
transcript,
of
there's no
South
confusion.
Carolina.
I'm not asking you to put that into evidence. I'm asking you to
Well,
let
I
the
don't
jury
see
know.
how in the world I can question the juror about something and not put it into evidence. You can't have your cake and eat it too, Mr. Harpootlian. You could have been very satisfied with the answers that were already given.
Uh-huh.
But you have chosen to ask about this.
Withdraw the request.
Denied.
Boom! Boom!
Your Honor,
Boom!
all the time we ask witnesses to examine a prior statement.
Mr. Poot, I made my ruling. Please take your seat.
Oh my God, I'm dead.
All right.
Motion
Bring
to
me
withdraw the
Juror Z.
request. Motion denied. This is not the one you want to fuck with, Poot. She is not the one. Today is not the day. Damn!
Get me another copy.
It's in here.
Yeah.
For everyone in the chat saying this is better than TV, you are correct. This is much better than any TV show you're ever going to watch. Live court is unpredictable. It is spicy. And this morning, they are fighting for a new trial for Alec Murdaugh, and they might well get it. For all of you that are early birds here, welcome to court, man. They are going to bring this juror back in and ask some more questions. We are questioning the first juror of the day.
To a
And this is
representative of
additional
Mr.
questioning.
On August the 14th, 2023. And I have this in my hand at the present time. And I'm going to hand it to you. And I'm going to ask that you read it. Tell me when you completed reading it. And then I'm going to ask you some questions.
So we are going to get into some follow-up questioning after this juror's memory is refreshed with their affidavit. I am at a loss for words about everything that has happened this morning. Like, I am stunned after this juror submitted an affidavit that said they were influenced by the other jurors, that this juror turned around and said that they were influenced by the things said by Miss Hill. The prosecution does not want to do this case again, but the defense absolutely wants to do this case again. Justice Toal was the first female Chief Justice of the Supreme Court in South Carolina and is vastly experienced.
First paragraph, of course, is a statement
She is
that you
now
are a juror
essentially
in the case.
cross-examining the
Second paragraph says,
juror.
Toward the end of the trial after the President's Day break, but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury, quote, not to be fooled, unquote, by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testifies. Is that what your recollection is of that statement?
This juror said in their questionnaire, I assume that to mean Mr. Murdaugh would lie when he testifies.
Yes, ma'am.
Is there anything in the statement that, on reflection, you think is not correct?
No, ma'am.
All right. Number 3, she also instructed the jury to, quote, watch him closely, quote, immediately before he testified, including, quote,
I'm saving your
look at
questions
his
till we get
actions,
to a
quote,
break.
and, quote, look at his movements, quote, which I understood to mean he was guilty. Is that an accurate recitation of your view of the matter?
Yes, ma'am.
Holy shit.
Number 4, paragraph 4. Immediately after he
Becky.
testified, the foreperson said Mr. Murdaugh was crying on cue.
He was, though.
Is that an accurate statement?
That's not no lies detected on that.
And heard?
Yes, ma'am.
5, the foreperson criticized the former foreperson for handing Mr. Murdaugh a box of tissues when he was crying on the stand while testifying about his murdered son. She told the jury we cannot interact with Mr. Murdaugh because that's what the defense wants us to do. Do you still stand by that recitation of that conversation?
Yes, ma'am.
All right. Number 6, the jury frequently discussed the case during breaks before deliberation.
What?
Is that correct?
What? That's new information. Wait, what?
Yes,
what
ma'am.
what the fuck did you just say? What the fuck did you just say? Because that's completely improper.
Breaks before deliberation.
Wait, no, back it up. Back it up.
Because that's what the defense wants us to do. Do you still stand by that recitation?
This was
of
not
that
filed.
Conversation?
Yes, ma'am.
All right. Number 6, the jury frequently discussed the case during breaks before deliberation. Is that
Can't do that.
correct?
Can't do that.
Yes, ma'am.
All right. Number 7, toward the end of the trial, Ms. Hill came into the jury room a lot. Is that your recollection?
Yes, ma'am.
Oh my God.
Ms. Hill and the foreperson had private conversations on multiple occasions. The foreperson would tell the bailiff that she needed to speak with Ms. Hill. Ms. Hill would arrive, and then she and the foreperson would go to another room for a private conversation.
Wow.
Conversations typically lasted 5 to 10 minutes. The foreperson never said anything about the content of the conversation. For example, she never communicated logistical information after these conversations. This happened 2 or more times, more frequently towards the end of the trial. Is that still your recollection of the interaction?
Yes, ma'am.
Doc, this is my question.
9.
If all the other jurors say that this is not what went down and no one reported it, the egg lady juror was asked about this in chambers before she was dismissed and said that no one was discussing this case. This is very different from even contemporaneous reports from court with egg lady jurors saying, no, we haven't discussed the case. No, we haven't been talking to Miss Becky, which leads lots of you to be asking in the chat, what if this person is not telling the truth? It doesn't, at this point, it matters. But with these answers, I don't know if an appellate court is going to uphold anything other than a new trial. So this is fucking crazy. I have seen some crazy shit in court. This is crazy.
When we began deliberations, Ms. Hill told us this shouldn't take us long, quote.
A lot of
And
jurors said that. A
If
lot
we
of jurors said
deliberated
that.
past 11 p.m., we would be taken directly to a hotel.
And they weren't prepared
We
for
had
that.
driven from our homes that morning and were not prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take smoke breaks, but they were told they could not smoke until after the deliberations
Not everyone
were
remembers
complete.
that.
Did you hear that,
Yes, ma'am.
including the business about the smokers?
Yes, ma'am.
All right. Number 10, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors.
Which is allowed. If you feel pressured by the other jurors, that's part of deliberations. Feeling pressured by what the clerk of court said is not okay.
Is that an accurate statement about your verdict?
So which
Yes,
is
ma'am.
it? So which is it? Was it Becky or was it the other jurors?
After the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group to reporters from a television show.
Oh, I believe that.
Is that an accurate statement of what she said?
Yes, ma'am.
And did some jurors decline to do that?
Yes, ma'am.
This is something. This is there is nothing realer than court, man. The fact that nobody's hyperventilating goes to their professionalism. I'm going to also say our feed today is coming to us from Luna Shark Media. You know
Juror
Luna
Z,
Shark from the
I
Murdaugh
asked you
Murders podcast now,
previously,
True Sunlight.
Was your verdict on March the 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk
I
of
appreciate
court?
them making their feed available.
You answered that question, yes. In light of what you said in the affidavit,
Is that still
which
true?
is I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors.
We need you to explain, ma'am.
Is that answer that I just read a more accurate statement of how you felt?
Yes.
Your Honor.
Overruled.
Yes, ma'am.
All right. So you do stand by the affidavit.
Yes, ma'am.
Very good. Thank you. All right.
They walked that
You may
back a
go to the
bit.
jury room.
That Poot's not going to
and
let
me
that
just
go.
explain to you what the procedure will be. I'm calling the rest of the jurors, of course, one by one. When I'm finished with that, I will bring you out as a group one more time, and then you're free to leave. You don't have to stay. Okay? Very good. You may go to the jury room. What's that?
Before this juror is excused,
Yeah,
but
Poot's
after
not done.
Poot steps out, I'd like to address
All
the
right.
court.
All right. You may be excused. Yes, sir. Mr. Harper.
Your Honor, we objected to the questioning because
Maybe not.
this
Maybe
juror
not.
gave 2 statements under oath, one in an affidavit and one here to you today. The one here today was Becky Hill influenced her verdict.
That
The one she
wasn't.
gave in an affidavit 6 months ago was based on jurors. It could be both. Your Honor picked out the one in the affidavit from 6 months ago and said, is that a more accurate statement? that presupposes and suggests to her what she should say. And we believe that this juror's testimony, and Your Honor, I'm afraid what you're going to say is, well, she said the affidavit was more accurate than what she testified under oath here today, and therefore I'm not going to consider her testimony. And I think that's where we're heading here.
friend.
I ask you to bring her back in, explain to her there's nothing wrong with it both being true.
I have declined to do that and overrule the objection.
Oh, the appeals on this are going to be insane. Poot's
Mr.
pissed.
Bailey? Yes, sir.
I understand why he's pissed. Something is happening in this court. The jurors are coming in. Something was going on. Poot's walking around like he doesn't have a care in the world. This is a very unusual hearing.
Counsel,
A very
I have
unusual
to report
hearing.
this to you, and I'm
Something just
very,
happened.
very unhappy about it, but there's nothing to do but put it on the record, and then I will
Fuck.
proceed with questioning the rest of the jurors.
Fuck.
The jurors' cell phones were not confiscated or taken from them, and they tuned this thing in on court TV and listened to all of what just went on.
Thank God it wasn't us.
You may make whatever statement you like to make, and then I'm going to go on and question the jurors.
Did anyone
I will
tell
you
them
in advance,
that they can't?
I am not going to stop the proceedings or do anything to interrupt.
Shit.
Get the rest of this on the record. You might imagine that they no longer have their cell phones with them.
Your Honor, we have a 5-minute recess to discuss what we need to put on the record. I mean, this is.
I'm not going to take all day on this thing. I report things as they come to me.
False.
I will give you a couple of minutes, and then we're going to. They were late getting here. I didn't get to start on time like I wanted to, so I need to just calm down a little bit. But I tell you, don't take any long period of time. Court will be in recess for 5 minutes.
I am shocked.
Just a minute.
I am flabbergasted that this is what's going on.
Now, you about to do something that I've already said I'm not going to allow to happen. And that is, you've got standing next to you a member of the team that represents the.
She's looking at Poot, it seems, saying, you're fixing to do something I'm not going to let you do. Damn.
Juror. And I can tell you, Mr. Harpootlian, I made a ruling early on.
Do not play with me, Mr. Harpootlian.
When Mr. McCullough was in court, when Mr. Bland was in court, that I was not going to allow the attorneys to participate in formulating the procedure for this hearing. But I have not. I indicated that I would not allow the lawyers for jurors to participate in this hearing. And so I'm not going to do that. I can just tell you that. And
This lawyer is one of Dick Harpootlian's good friends, also threw a birthday party during the trial for Clerk of Court Becky Hill. I read the emails between this attorney and Becky Hill during the trial in that email FOIA dump. And this attorney is standing in the well of the courtroom wanting to have a say because that juror that just testified that was impeached on their affidavit is represented by this attorney. And the judge is like, what you're not going to do is get into all this. Y'all get a snack. Today's going to be fucking crazy.
What you want to do is, by indirection, tell me what the lawyers for the juror would say. I'm not going to accept that.
Your Honor, my understanding is she'd like to approach to ask if the juror can be excused.
No, not yet.
Nobody's going anywhere.
I actually approached.
Now, Mr. McCullough can be excused. There's still plenty of you lawyers and you can do it. I didn't want him to come to begin with, so I love him dearly, and he can go anytime. And I speak on behalf of Amy McCullough, his wife, when I tell you that.
Your Honor, I actually was here to let both of them know that I was going to ask to approach to talk about a security issue very quickly.
Come up here. Lord knows, I tell you what, Murphy's Law. What can go wrong will go wrong at the worst possible time, and Murphy was an optimist.
Murphy's Law. What can go wrong will go wrong at the worst possible time, and Murphy was an optimist. All right, let's get us caught back up to real time because they are addressing a security issue. Holy crap. I don't have words. You cannot make up the stuff that happens in court. It is absolutely bananas. And the judge is like, I'm not going to be here all day with this. The hell you're not, Your Honor. You set aside 4 days because you know what? This type of shit. I am stunned.
For the record, Your Honor, we would ask, as jurors are brought in, we would ask that you ask them if they watched or heard anything this morning from their cell phone or other jurors about what occurred in here this morning with Juror Z. And if so, what was it?
I'm going to say, ask each one of them something about this. Whether it's exactly what you want, I don't know. But I will ask them something about this or make some direction to them about it. I'm not going to get into who shot John about what they said in the jury room today. I'm not going to do that. But I will try to, as best I can,
wow.
This question of who heard, of them hearing parts of the examination of Juror Z.
Your Honor, this morning I think you
He's not done.
instructed them not to discuss these matters among themselves. So if they have violated that, again, I think it's important for you to make that inquiry.
I'm going to make it as I see fit.
Thank you, Your Honor.
Yes, sir. All right.
I'd like to discuss the matter with you before we finish with
Of
you.
You may go to your jury room.
You have a
and
matter.
Keep yourself ready. I don't know if I'm going to have any further questions, but as far as I'm concerned, the questions that I'm asking are at an end, but I need to consult with the attorneys before I can dismiss you. You may go to your jury room.
Whew. This is the third juror that's testified today of 11 that's going to testify. This is wild. What does Poot have to say now? Poot's looking at what looks like an affidavit,
Yes, sir.
would be my guess.
Your Honor, in interviewing the clerk of court for Barnwell County, who worked as an assistant to Ms. Hill during this
What does this have to do with the last juror that just testified?
trial, and interviewing the alternate juror who was not, wasn't needed, wasn't dismissed for any particular reason other than wasn't needed. Both of them indicate they believe that Ms. Hill transported this juror by her personal vehicle or a bailiff's vehicle at least once during the trial.
What?
So I would ask you ask her, during the trial, did Becky Hill either drive or ride with you in a vehicle before or after court? If so, what, if anything, did Becky Hill and you discuss?
What the fuck? Bring that up before.
What's your position on that, Ms. Waters?
Your Honor, I have no objection to that.
Why the fuck is the clerk of court driving anyone anywhere? First of all, the appearance of impropriety is ridiculous.
All right,
Second of all,
juror.
the potential liability is
Juror C, returning to the stand.
stupidest shit I have ever heard. What happens when they get in a car accident? They're not covered the same way like a transportation bailiff would be. Are you kidding? Are
The
you
same juror.
Are you
Yes.
fucking joking me? What the hell is happening? Of all of the nonsensical bullshit, this is absolutely bananas. How messy is this case going to get? And we've got all of the SLED law enforcement sitting there behind the prosecution table. I am sure they are scratching their head about how this conviction, this case that they worked on, might get unwound by one elected official. Oh,
Thank you, ma'am.
my
Of course, you're still under
God.
oath. And I have this question for you. During the trial, did Becky Hill either drive or ride with you in a vehicle before or after court? If so, what, if anything, did Becky
What, if
Hill and
any?
you discuss? Do you recall that at all?
Could you please ask that again?
Yeah, it's kind of
Could you
compound.
Please ask the question again.
Sure.
Sorry.
During the trial, did Becky Hill either drive or ride with you in a vehicle before or after court?
No, ma'am.
All right. Then I don't need to ask the second question. This will conclude your testimony. You are dismissed. I'm going to ask the jurors to stay with me until I've completed this process, and then you are free to go.
Poot, what do you got to say about
Thank
that?
you so much.
And now Poot's going to put something on the record.
Please, Court, Your Honor, I would move for the record that I be able to question Juror Z to follow up on what I believe the court is confused.
Your Honor, I would like to question my juror. I think we need to question Juror Z more. Juror Z is the one who said the only thing that's going to help us here today. Please, God, let us ask more questions. I don't think this is going to fly.
Just about.
Very good. I deny the request. Anything further?
Said what she said.
All right, bring me the jury.
Bring the jury.
You are dismissed this time. You may go. Thank you for your service. Excuse the jurors.
Remove the jurors. Let's go into live court with Alec Murdaugh coming back after the lunch break. They've got every deputy in South Carolina, it seems, bringing Alec Murdaugh in.
Please report, Your Honor.
Yes,
All
sir.
right, let's hear what Poot has to say.
Your Honor, we last week discussed the standard by
Friday.
which you would proceed during this proceeding and evaluate the evidence. We argued that you should
Sooner than Friday. That happened before that. So let's continue.
use a case called Remmer. You rejected that. But under any standard, as I understand it, the burden of proof is on the defendant
Yes.
to show certain statements were made or certain
Yes.
conduct happened. So far, Your Honor is called
Kadora,
as
recover
court
well.
witnesses, 12
Don't laugh
witnesses.
too hard.
We were not offered the opportunity to cross-examine
I'm going to answer this
them.
question when we have a break.
So we've not had the opportunity to present any evidence whatsoever. And before the state presents evidence, I believe that we should be able to call witnesses. And I would ask the court to allow us to present
This is an
some
evidentiary-
evidence before
This is an evidentiary hearing, and Poot is saying the burden's on us. We should present witnesses before the state brings in Becky Hill.
state comes up with rebuttal. And by the way, under the cases you cited, they have no affirmative obligation to present anything at this point. There's no requirement they
He's
they
right that
present
the
anything.
burden's on the defense.
So I would ask you to allow us to call a witness or two before you make a decision as to whether or not they need to call a witness.
The state?
Your Honor, we obviously have argued very extensively some of the cases, and I think the South Carolina jurisprudence is very clear that while an evidentiary hearing is appropriate, and that's what we're doing here, that manner of inquiry is purely within the discretion as the trial judge sees fit. This is not a criminal trial where we're here with the jury to present the normal, criminal trial process. This is a inquiry that is very much directed
By the court.
by the trial court, and what the trial court thinks is appropriate. And so the state certainly is comfortable with the inquiry the court is conducting. And my understanding is, as far as
He's got a list
putting
of
up,
questions.
Ms. Hill, this is the manner in which the court wanted that evidence presented, and so we're happy to comply in that regard. But we think that this inquiry is within your discretion, and we have no issue with the manner in which Your Honor's proposed to conduct it.
Please, the court, Your Honor.
He wants to be heard again.
Certainly, the conduct of this hearing is within your discretion.
Yes.
What is not is who has the burden of proof. We do. And we can't meet that burden if we can't call witnesses. And so I'd ask the court to allow us to call witnesses. And if at the conclusion of us presenting those, you believe the state
He brought this up on
has-
Friday a bit.
is required to present evidence.
And we heard that.
To counterdict that evidence, or in some way, I'm not quite, since Remmer is
Dict.
not the standard, I'm not quite sure what they have to prove. But that's an argument down the line. I believe we ought to be able to call witnesses now. And we have witnesses which would substantiate the burden we have to show you that statements were made by the
Two deliberating jurors.
clerk of court, and that those statements had impact on a juror or jurors.
I've got a couple of reactions to that. Number one, from
Great.
The pretrial was the time to figure out exactly what we were going to do here.
Uh-huh.
And I think it comes at the last minute for you to now come and say we want to present witnesses. You briefed the matter of witnesses. We had a long pretrial. After I made my rulings on what I thought the scenario was that should be used based on State versus Green, you lodged objections to that, but you did not offer at that time any information about who you wanted to call.
He did bring it up Friday, though.
Filing in one of your briefs. It comes pretty late in time for, in my view, for you to do that now. Second thing is,
you're too late, sir.
I gave the defense a big break when I allowed you to be the cross-examiner and the state to be the presenter of Becky Hill. She's really a witness that each side needs to prove their view of what happened in this matter. The state puts her up to try to show that there was no impact by anything she said, and that some of the things your witnesses say.
And I don't know how Becky Hill can say, I didn't impact them. She's not in their minds. She can say, I never spoke to them. Yikes.
She says we're not. So there's a conflict in the evidence there.
There is a conflict in the evidence.
I'm not going to rearrange the situation and go to any witnesses of yours right now. I'm going to see what Ms. Hill has to say. And then afterwards, we can talk about whether there's any need for any other witnesses.
She's like, I'm disinclined to acquiesce to that request. Poot.
Factually argue this with you. We did not understand. We assumed you'd adopt Remmer because that was.
Well, I don't know why you assumed that.
She told you she wasn't, sir. She told you she wasn't adopting the standard in Remmer at the last pretrial hearing.
Because the South Carolina Supreme Court said very clearly that we do not go by the guidance of the 1950s case of USB Remmer.
We do not believe that's what Justice Kittredge has said.
He said it straight out, as clear as a bell can be, but I ruled on that.
Yes, ma'am.
And the South Carolina Supreme Court's going to have plenty of chances to decide that they want to modify Green.
Well, when we were somewhat taken aback by a ruling as a result, and that ruling
he said he didn't understand. That was over a week ago.
Came at a point where we didn't know what these witnesses were going to testify to. So we now, and by the way, you've set aside 3 days for this. What's the hurry?
When you have to argue, Your Honor, we've got time. She's not listening to you, sir.
Gentleman is facing life with no parole. We should take this in a very deliberate way. He's got a 14th Amendment right to ensure that he had a fair trial.
All these arguments should have been made before this time,
Why?
Mr. Mark. Well, Mr. Harcourt.
Why?
I've told you how.
Why? All these arguments should have been made before now. Why?
I'm going to handle this thing. Your objections are noted and they're on the record. But right now, what I'm going to do is what I said I would do. We're going to call Ms. Hill and see what she has to say. I have no idea who all you want to call as witnesses or whether they're here in the courtroom at the present time. But we'll get to that after Ms. Hill testifies.
Yes, Your Honor.
Just bring it to your attention.
I'm just getting an email on.
Oh, shit.
And put this on the record right now. I have
an email about what? God damn it. An email about what?
A communication from Mr. McCullough.
And her team today.
Joe McCullough.
It's only that is copied to Mr. Harpootley and Mr. Griffin.
Joe McCullough is the defense attorney that represents Juror Z, who was the first juror to testify this morning. Shit.
Mr. Waters and Attorney General Wilson. And basically says his client, Juror Z, wants to enhance the testimony she gave with some sort of affidavit that he wants me to look at, and I have looked at it.
Juror Z wants to enhance their testimony? Are you... Jesus Christ.
I want to hear from the state and the defense, but I can tell you I'm not inclined to get back into the testimony that's already been taken by these jurors. Her inconsistencies, whatever they are in the record, and she now wants to have another bite at the apple. I'm not.
You don't get another bite at the apple. I don't. This does not leave a good taste in my mouth.
Your Honor, The jurors testified. The court conducted the inquiry.
Done.
She answered the questions. I would agree with Your Honor that multiple bites at the apple are not warranted. So we believe we should proceed forward as the court has indicated.
Agreed.
Mr. Harpoot, then?
Remember, Dick was trying to have this juror recalled again. That is exactly what they wanted. They wanted more from Juror Z. Juror Z is the juror who testified that they were influenced by Becky Hill, but there were some, I don't know, contradictions. But getting an email with another affidavit with this juror being like, no, I need to tell you more is wild.
Your Honor, I'd note two things. The first thing is we asked to be able to examine this juror.
You did.
Denied that request.
Yes, she did.
She's not our witness. She's not Mr. Waters' witness. She was the court's witness and a juror and you commended all of them on their honesty. She's attempting to be honest. This process we're going through is an effort to seek the truth. This is the truth. I don't understand why it can't come in.
I think I understand what your position is.
So we'd ask you to make it a part of the record. You can say
you've been heard, Mr. Harpootlian.
But it should be a part of the record.
Well, I'll give some thought to whether this thing should be a part of the record.
Bring Miss Hill!
I'll tell you this.
This is highly unusual.
Witnesses don't get to get on the stand and testify under oath, and
you witnesses don't get to come back and do it again. You don't get a do-over. You're sworn under oath. You're in live court. That you say what you say. You don't get to think about it and then come back and be like, just kidding. I want to clarify. And I have to wonder if that was impacted by anything seen outside the courtroom after this happened.
Then seek to add or change or deal in any way with their testimony. Those questions were very open-ended questions that asked for her responses.
I do not like this at all.
If they're inconsistent, she can't come up now and try to close the loop of consistency by some additional testimony. I am not thinking about allowing that to be done.
With all due respect, Your Honor, we believe, and we said at the time, the way you questioned her put her in the position of saying, yes, that was my verdict then. We think.
How do you know? How do you know what this witness is thinking so well, Poot?
And we couldn't examine her. And Your Honor, to say now that this affidavit doesn't accurately depict her position is to deny fact, the truth.
You've already said that once. I know your
that's not how this works.
Position on that matter, but I decline to adopt it. All right.
We'd make this an exhibit as a proffer for our case. This affidavit, we proffer it for our case. We have the burden.
No, we know you have the burden.
I'll give some thought to it. I'm not ready to deal with that right now. I have looked at it just in the moment.
What the fuck happened over the lunch break? And what is the time on that email?
And we'll close that loop before the end of the day.
Your Honor, again, I indicate we have 2 more days. We don't have to wrap everything up today.
She's disinclined to acquiesce to that request.
All right. Mr. Waters.
Thank you, Your Honor. The state calls Rebecca Hill.
Cue the oh shit music. Oh shit. Becky Hill's gonna be testifying, but not before there was some courthouse fuckery. I have never. What is going on in this court? Jeez. This. Will she take the 5th? Will she not take the 5th? Will she admit to talking to the jurors? Will she not admit to talking to the jurors? Her lawyer is going to sit right there next to her. I'm sure Becky Hill did not ever expect that when she became the elected clerk of court of Carlton County, South Carolina, she would end up on the witness stand with a double homicide trial that might be overturned because of the shit that came out of her mouth. Wild.
Good afternoon, Ms. Hill. How are you?
I'm fine.
Yeah, I'm sure that's not true.
Started,
Lies, perjury. Perjury. She said she's fine. There's no fucking way that can be true. I've seen her emails. She is pissed as hell about all this going on. Come on now. Lies.
State your full name for the record and spell it for the court reporter, please.
My name is Becky Hill. Last name Hill, Hill.
All right. And if you would, just give us, you're currently the clerk of court for Colleton County, is that correct?
That's correct.
And just very quickly, if you would, what year were you elected as clerk of court?
At the end of 2020.
At the end of 2020?
Yes.
Let me go ahead and just kind of get straight to it.
Yep.
In your capacity as clerk of court and in your previous experience being a court reporter, were you familiar with the rules that apply to court staff as it comes to interactions with jurors in the course of a criminal trial or a civil trial for that matter?
Yes.
All right. And could you tell the court generally what those rules are as far as what contact is permissible and what contact is not permissible, just very quickly?
The clerk of court and anyone else, court reporter, we're there to, my understanding would be to make sure that everyone's taken care of. Do you need some Kleenex? Do you need some water? Different things like that, just to make sure that they're taken care of.
Where it ends.
Is it common for clerks of court to have interaction with jurors during the course of a trial to see to those various logistical needs that you just
Normally it's
described?
a bailiff.
Yes,
And did that happen in the Murdaugh case?
it did.
At any time, did you interact with any juror in an attempt to influence their view of the facts
I think
in
that's
the Stacey
leading.
Murdaugh case?
No.
All right. Now I want to ask you some specifics
Doesn't mean she didn't
about
talk to
that,
him.
and some allegations that have been raised. At any time, did you tell the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys?
I did not.
At any time, did you instruct the jury to watch him closely and look at his actions?
I did not.
At any time, did you instruct the jury or tell the jury to look at his movements?
No.
At any time, as the jury moved to deliberate, did you tell the jury this shouldn't take long?
No.
At any time, did you tell the jury that the defense case, watch out for the defense case, they're going to try to throw you off, or anything along those lines that was meant to influence the jurors against Mr. Murdaugh?
No.
Let me ask you,
I'd be much obliged.
if you ever made any comment to the jurors about the fact that the defendant was going to testify. Did you have a conversation in the presence of the jurors?
Can
prior
you
to
just
the
stop
defendant
and let her
testifying
answer?
about the fact that he was about to testify?
Great.
It wasn't directly related to the jurors. I was talking to Mr. Bill, who was our bailiff foreman, our bailiff over the jury, and I was talking to him about that.
All right. And what did you say?
I told him what I had just come from downstairs telling my security and bailiff office, that Judge Newman had allowed more testimony in regarding the financials, and that also the defendant had decided that he may testify.
All right. And where were the jurors at the point that that conversation occurred?
There were a few jurors standing in line, and there were some in the bathroom, I'm sure, because they said they were waiting on jurors to get out of the bathroom. And there were some in the jury room just milling around from what I could see, looking down the hallway.
Then you shouldn't be having that conversation right there.
And again, what were the words that you said during that conversation? What were the effect of them?
To Mr. Bill.
Yeah. And what did you say?
I told him that that Judge Newman was allowing more of the financial evidence in.
Why are you having
which
this
would
conversation in
prolong
front of the jury?
The testimony in the trial a little bit. And also that the defendant had decided that he was going to testify.
Did you say anything about this being an important day? Pay attention. We'll get coffee for you. Things like that.
I usually give a little pep talk to the jurors. It's
I'm sorry. What kind of a pep talk do you give to the jurors? Lunch is at 12. There should be no pep talking. What?
Sometimes hard sitting a long time, but my usual, and I do remember saying, pay attention. It's a big day today. Whatever you need, let Mr. Bill know or one of the other bailiffs, and they'll be glad to get it for you.
Did your comments or were your comments in any way phrased in favor of one side or against another side? Or were they more of a neutral comment about?
Well, there that is.
No, it was not for one side or the other.
Giving them a pep talk is not part of your job. You don't need to pep them up. Pay attention. Big day. Defendants testifying. Undertone. Don't fuck it up. This is why you can't talk to jurors. It's so inappropriate. There are no pep talks. The judge tells them to listen to the testimony.
Were you
this is not her
when
job.
The jury went to the Moselle property to conduct the jury view.
I was.
All right. And was Judge Newman there as well?
He was.
During the time that you were on the property, traveling there, traveling back, did you have any conversation with the jurors where you made any comment about the substance of any testimony or any comment about the merits or the strength of the case?
No.
Did you have a quick comment to the forelady about how the property was beautiful and there were tea olive trees there that bloom and smell good, or words to that effect?
I did.
All right. And was there any other conversation related that you had where you made any comment about the case or the merits or anything like that?
Oh, no.
You shouldn't have been talking to them at all, though. You shouldn't have been talking to them at all. I don't give a shit what kind of trees are on the Moselle property. You have no reason to be talking to a jury at a jury view of a murder scene.
Did you understand, being a longtime court employee and clerk of court, that is outside the boundaries of what is appropriate interactions with the jurors during the course of the trial?
Absolutely.
And at any time did you violate that rule that you understood?
I did not.
Okay, ma'am. She shouldn't have been talking about the case with them at all.
We spent 6 weeks together, didn't we?
We did.
Don't try.
6 weeks,
Poot, she's not happy with you.
Helpful to me as you could be, correct?
I was.
Accommodated just about every request I made.
Yes, sir.
Wait.
The court sound system is having a moment.
Oh yeah, we're old friends, right? We spent 6 weeks together in a very pressure-filled situation.
We're old
correct?
friends, sir?
It was a long 6 weeks.
It was a long 6 weeks.
We're old friends.
Now, let's talk about this book for just a second. When did you first decide you were going to write a book?
When did you depublish it?
I think a thought was there, a very fleeting thought before the trial.
Did you take any steps before the trial?
I've seen your emails. You were talking about it during trial
Of the trial
with other reporters.
Begin writing this book or working with somebody on this book.
Oh, no, sir.
When did you and your co-author get together?
It was
in her emails during the trial. There is a journalist coming from France who says, I'm coming from France. I'm working on a book with this, blah, 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 blah. And she's like, I think a book would be a great idea. That's before the trial even starts. I think I want to write a book too.
Several weeks after the trial.
Okay.
The thought was there.
Did you talk to anybody about the fact you were going to write a book before the trial?
There were several anchors and several journalists that I did speak with about the possibility of writing a book.
Yes. Yes.
Did you take a juror home one night?
I didn't take a juror home one night.
Did
No,
Mr.
sir.
Mr. Polk and you take a juror home one night?
No, sir, we
Okay,
didn't.
you never gave a juror a ride in a car with Mr. Polk or without?
No, sir.
Okay.
And the jurors said the same thing.
You have described in your book your role as Switzerland. Is that correct?
Correct.
Okay. And that is that you should not be in any way opinionated about what's going on in the trial. Is that correct?
That's true.
Her emails don't.
Yet in your book, you
don't
indicated a
concur.
number of different points during the trial. You had concluded he was guilty. Is that correct?
Her emails indicate that as well.
I don't know if her conclusions in the book are in any way relevant to what occurred during the trial and whether or not there was any communications with the jurors, which is the sole issue that we're here for today, is whether or not Ms. Hill had any extraneous influence on the jurors. And so I think this is going a little far afield. We object to the relevance here.
Yeah, I think
Let me give you an example. You indicate riding back from Moselle that you and 3 other people were in a car, and you all decided adamantly, I think was the word you used, that he was guilty, that he had killed his wife and son. Is that what you put in the book?
I can't remember if I put that in the book, but if you say I did, then I will agree
that
with
happen?
you. We did have a conversation about what each of us thought.
And they all 4 agreed that he was guilty, correct?
all
And
four
none of
them.
us were jurors.
No, trust me, I know that. But you had an abiding conviction, at least by the time of the Moselle visit, that he was guilty. And the other people in the car with you were bailiffs, were they not?
No.
Who were they?
Some were not bailiffs. One was a court reporter. One was our security officer, head security, and another was a
dead
deputy
ear.
sheriff.
Okay. But the 4 of y'all rode out there, and based on what, and I mean, I can, you want me to read to you how chilled you were and how you felt that poor Paul and Maggie had been executed by him on that scene, that visiting the scene convinced you that he was a horrible, horrible murderer? You want me to read that to you? Or you will concede that's what you wrote?
Yes.
I will
No, read
concede
it.
that's what I wrote, but if I may, I would say that a lot of that is poetic license in writing a book and in making it sound like that.
So did you
Okay, so
lie?
some of it's poetic license, and some of it you just stole. You purloined it from that BBC writer, right?
I object to not only the relevance, but the scope of cross. I would object also under rule.
Nope. The judge is going to let that in.
I don't believe that that's appropriate cross-examination.
Overruled.
Yeah.
Continue, Mr. Harpootlian.
Did you steal part of the book?
I did plagiarize,
Okay,
Mr. Hartfield.
that's stealing, isn't it?
And it is, and for
Okay.
that I'm very sorry, and I have apologized.
Okay.
Ma'am,
And that makes it okay?
What I did, and I apologized for that.
And part of the book is, you say, literary license? Exaggeration?
no, she said poetic license.
I wouldn't call it exaggeration.
Okay. Now, let me
Uh,
ask you this. Is Switzerland, and this is, you're saying this is happening while you're supposed to be Switzerland, you decided the defendant's guilty.
Runkle,
And,
I agree with you. Runkle
if
said this is
Ms.
Poot on his
McElveen
game.
says
Yes,
that
it is.
It's going to make you more money
Yes, it is.
if he's found guilty. Don't
Poot's
you think
having a
it's
very good
reasonable
time
to
with
assume
this.
that you may have crossed the line from time to time?
Your Honor, I object to the form of the question, assuming facts not in evidence.
The prosecution's really working here, but this is a hearing in front of the judge, and they're not going to get very far with those objections. They're trying to stop the train wreck that's happening. There's no stopping it. Creighton, you can object all day long, and some of them are probably proper objections, but we're not in front of a jury. We're in front of a judge at an evidentiary hearing, and she's going to let this happen. So it's just going to happen.
Can you repeat that question one more time,
I'm
Mr.
not going to repeat
Hartfield?
it. Let me just move on to something else. Let me ask you,
Poot,
you
don't
had
let it
interactions
go.
with some jurors, and I believe in a conference in the judges' chambers, you indicated that you had seen a
Oh, not the Facebook post.
post on, is it Walterboro Word of Mouth?
Not the Facebook post. Not
Again, I object. I think he's delving now into the Facebook inquiry. We believe, again, that that's irrelevant to the inquiry, for Your Honor.
I will allow a limited, he's, as I understand it, trying to impeach her testimony and explore her credibility. And I think I've already told Mr. Harpootlian that I don't want a whole trial about the business of Facebook and the egg juror, but I will allow limited examination on this point. You may proceed, Mr. Harpootlian.
Am I oversimplifying that? It's in your book. You saw something on Walterboro Word of Mouth, which appeared to you to be from the ex-husband of one of your jurors. Is that correct? Am I oversimplifying that?
I remember reading one night something on Walterboro Word of Mouth, and when I was in the courtroom on a Monday morning listening to the judge and the attorneys talking about a matter, it sounded like it was relevant to each other.
Okay. And you became aware somehow that this juror had a restraining order out for her ex-husband?
How?
She told me that herself.
Okay.
When?
And
What?
tell me how it came for her to tell you about that.
Yes.
Where did she tell you?
She was very talkative, and when I was instructed by Judge Newman to go and get her from out of the jury room with a deputy following me, she was talking to me all the way back to the judge's chambers, and she mentioned that there were restraining orders out when they had divorced.
So how did the judge, who brought it to the judge's attention about this Walterboro word of mouth thing?
I let the judge know, thinking that it could be related,
Okay, and you let the judge know what?
that I had read something on Walterboro word of mouth.
Okay, and that you knew it was tied to that juror?
I didn't know that it was. I wasn't sure at all.
Who do you think it was tied to?
From what y'all were talking about at the bench, I felt like I needed to let him know, just in case it was related. There was something about an ex-husband and an ex-wife and somebody being on the jury.
You didn't tell the judge.
But that doesn't make any sense. That doesn't make any sense. She's like, there was something about an ex-husband and an ex-wife and somebody being on the jury, but she didn't know that that juror had an ex-husband until they were walking back after. That doesn't make sense. That doesn't track.
Had found what we call the apology post. You didn't tell the judge that?
I didn't call it that, no.
You don't remember producing it, saying producing it to the judge, saying this is a post in which the guy that posted it on Friday night says the devil got in him and drinking, and he apologized for what he posted. You didn't produce that?
My staff did, one of my staff.
But you gave that to the judge and gave it to us, did you not?
Yes, we did.
As if it were from that juror's ex-husband, correct?
Correct.
And you know it wasn't?
I don't know that, Mr. Hart-Bullion. No.
So, and this, you did not take that juror out and talk to her before you took her to the judge? Is that
I never talked to that juror about stuff like that.
How much money did you make off that book?
Ooh.
There was not a whole lot of money made off of the book after paying different things and paying for
no
some
profit?
expenses that went along with that. But I want to say roughly around $100,000.
Okay.
That's not a
That's not a lot
lot
of
to
money.
you.
No, especially when you publish your own book.
But
Is-
that was $100,000 you made.
100,000 in profit?
With my co-author.
Okay.
In profit.
In what
100,000 in
period of time?
profit.
6 months?
I would say 6 months.
Now, you also indicate in the book that the Murdaughs had a reputation of criminality, I think, is kind of what you put. Did you not?
Well, Mr. Hart-Bullion, my grandfather and Old Man Buster were very close.
What, were they criminals?
I wouldn't know.
You wouldn't know. But you believed and you published that the Murdaugh family had run that part of the state and they'd participated in criminal conduct, correct?
In the book, that was more of the literary ease that we take, I think, to make a story a little more interesting for the reader.
By calling people criminals.
Well, that's potentially defamation.
I guess what I'm saying is this. Were they criminals?
Your Honor, again, I object to that particular question.
Overruled.
Were they criminals?
I wouldn't know that.
Okay, so you
So
either
is it
made up
defamatory?
or you're lying about it? About the reputation of people that can't defend themselves? They're dead?
This is what he was working
You're going to
towards.
call them criminals? You did that in the book so you could sell a book?
No, I didn't do that to sell a book.
What'd you do it for?
To make it more
Made it
interesting
more
for the
readable, you
reader.
said?
That's what it
Which
is.
sells books.
Literary ease. Yeah.
What?
Literary.
Literary what?
The literary ease that you can take when writing a book.
With the
Literary
truth?
ease you can take with writing a book. You can make stuff up. You can lie. You can lie about people.
Not with that. I think the public perception was one that it was very interesting.
You're not writing a novel
during
or
this
fan
time.
fiction.
Let me give you another example.
He's right
I read your book
to
and I
ask
found
her.
this somewhat humorous. My co-counsel did not. In describing myself and Mr. Griffin, in the book you say that I neutered him. We've both been very interested in what you meant by that.
Oh, that's
What
personal.
do you mean by neutering Jim Griffin?
Mr. Hart-Bullion, it was a book.
Did you make it up? I know it was a book. The
Right.
Bible's a book.
Right.
I mean, just because it's a book doesn't mean you can lie in it.
It's just a word that was used.
The nature of that exchange.
Don't argue with the witness, but the witness, Ms. Hill, you're instructed to answer his questions.
She's answered, Your Honor. It was a book.
See if I can cut to the chase on this. I could read you chapter after chapter, verse after verse.
Do it.
Which is not true.
Let's do it. Where is it?
Okay? Not true based on my experience of
I'll
being
find
in a
it. I'll read
courtroom,
along with you.
and not true based on knowing some of the people you describe. You say that is
Compound.
Mr. Harputian?
I object. The counsel's just testifying right now as to his observations about the book.
Question, Mr. Harputian, please.
Find it with both
you
hands, sir.
conceded there are things in the book that you don't know to be true, correct?
Correct.
Okay. You would concede then that you have lied in the book.
It's only because I wasn't there at the time. I can't interview my dead grandfather. I can't interview Buster. There's just things that we can't interview them on. We can go by what was written in a newspaper and get facts from that.
And take the inference that one of the Murdaughs was a pedophile. You could have printed that, and they're not here to contradict it. You could have printed anything you wanted and made it up to sell books. That's what this whole scheme was about, selling books.
That's his point.
As you told Rhonda McElveen, if him being found guilty would sell more books.
Your Honor,
Isn't that true?
I'd object to the argumentative nature of the question, the compound question, and assuming facts not
Yeah,
evidence.
compound question. If what
It is a
you're
compound
asking is what she told
It is a
Ms.
compound
McElveen,
question.
go on and ask that, but don't.
It's his
Proceed
argument.
with,
It
yes,
is
Your
his
Honor.
argument. That's his
Testimony.
argument. That's
The
his
court's
entire
indulgent for
argument.
Just a moment. At the end of the trial after President's Day break would have been a Monday, correct?
In February.
Correct.
But before Mr. Murdaugh testified, did you tell the jury not to be fooled by the evidence presented by Mr. Murdaugh's lawyers?
Mr. Harpootlian, I never talked to the jurors about any of the evidence
If the
in this
answer would
case.
be yes or no, then you can explain. Did you say that?
No.
Okay. Did you ever instruct the jury to watch him closely immediately before he testified, looking at his actions, looking at his movements? Did you ever tell the jury to do that?
No.
I'm glad he's
Did you
pulling
ever
up the
tell the jury
affidavits.
to pay attention to Mr. Murdaugh's testimony?
I think she did.
To pay attention, not specifically to his testimony. I did tell the jury to pay attention
To what?
just generally in the hallway when I was speaking.
Not to him.
You shouldn't have,
No.
Just
shouldn't
any
have.
witness.
but you shouldn't
Right.
have.
Okay. You got any other books in the works?
No, sir.
I mean, doesn't this make a good book?
Ew. Ew.
Thank you.
You were asked about your book, and I don't want to get into too much detail about that, but you were asked about
Same.
some of the assertions that you made in the book. And you were asked if these were lies. Were they lies, or were they ultimately things that were based on inferences from newspapers and community stories?
There we go.
You are leading by. This is your witness, Mr. Waters.
He's been leading
so
the whole
please ask a
time.
direct question.
Thank you. Some of the statements that you were asked about in your book, were they lies, or were they based on your inferences from just general community knowledge and things that you had researched and knew?
Still leading, but I'm not.
It is still leading. Were they lies?
He's right about that, Mr. Waters.
He is.
Just ask a direct question.
Yes,
Did you lie in your book?
No, I did not.
but you plagiarized.
At any time, did you have any conversation with any juror in which you tried to influence their decision?
I did not have a conversation with any juror about anything related to this case.
Nothing further on.
All right.
And that's it. That's the testimony of Becky Hill.
Ms. Hill? I want you to turn your attention to a hearing
No, it's
that
not.
Judge Newman had about the alternate who was dismissed.
Nobody else asked.
Sometimes called the egg juror. Do you recall that hearing?
Yes, ma'am.
Well, then let's go back and talk about that juror. On examination in this courtroom, you said that she talked about a lot of things to you, but you didn't ask her any questions. But that's not completely accurate, is it?
Yes, ma'am, that is true.
Well, you asked her direct questions, and that came out in the hearing that Judge Newman had. You asked her questions before she was even examined by the judge, did you not?
Your Honor, I did not ask her any questions.
The judge doesn't believe you. She believes Judge Newman. She's got the transcript in front of her. Justice Toal does. That is transcript pages she is flipping through. Oh. You know, the defense asked that Judge Newman might need to be recused off of this because he might end up being a witness.
Examined by the judge in a hearing. Do you recall that hearing? It's the second hearing on this matter.
I do recall that hearing, yes.
And
oh boy. Justice Toal's going, timeline, receipts, screenshots, fucking everything. She's going through the whole transcript.
The court asked this juror about postings on Facebook. Did he not?
Correct.
Danger.
The juror said she gave Miss Becky my full access to my Facebook. And I put positive posts on it. I've done that for the past 3 years. Do you recall her testifying in that regard?
I do remember reading that.
And the judge said, has anyone posted anything on Facebook about you? And the juror answered, I was not aware of it until Miss Becky told me today. Do you recall that?
I do remember her saying that.
And do you recall the judge saying, what did she tell me? And the juror said, she asked me if I had an ex-husband, and I said, yeah. Did you ask her that?
I remember her saying this, Your Honor, but I did not ask her any of these questions.
And she further says, she asked me if I had talked to him about the case or being on jury duty, and I said no. I had questioned her about why she was asking me that. I haven't seen my husband since 2014. Do you recall her testifying to that?
I do remember that, yes.
And with that, having jarred your memory, do you recall asking her about her husband and his posts?
Your Honor, I don't remember saying anything about that.
Well, what was the post that you read in the...
It's now a trial about the Facebook post. That's where we're at.
Word of mouth.
Word of mouth. What was the nature? You read that, did you not?
I did.
What did it say?
My memory is a little fuzzy with that, but it was about a ex-husband who found out that his ex-wife was on a jury, and he didn't think that she would be a good juror. And it just sounded very similar to what I had heard the judge and the attorneys speaking about.
So you then went to that juror and questioned her about that, did you not?
I did not, Your Honor.
Well, she says in this testimony that she didn't know about the Facebook until Miss Becky told me. Was that incorrect?
That's true. And I'm thinking that it could have been someone, it wasn't me. I just know that it's not me.
Well, when the judge, the judge was questioning the juror about this,
the shaggy defense does
she
not
also
work.
said that she had 3 restraining orders against him. And she also said, I was very upset after she told me that. Like I said, I have 3 restraining orders against him, and I wouldn't have anything to do with him if I didn't have a child with him. But I haven't seen him since 2014. Y'all didn't discuss that, the restraining orders?
On the way from the jury,
you put it in your book.
The jury room to the back chambers where the judge was, she was very scared. She was talking about the 3 restraining orders that she had out on her husband at the time that they were divorcing. And she was scared that he would be trying to get back in contact with her again.
Well, how do you know that? Did she tell you that?
She was talking about that on the way to the jury room, to the chambers with the judge.
Well, why was she talking about it?
And in the court,
What precipitated that
in this
conversation?
hearing now that I'm looking at, that the court is conducting, she said they're asking about this Facebook post, and she said Miss Becky said she went to look for the post again, and that it had been deleted. I don't know who she talked to or anything else, but she said apparently. Do you recall her saying that?
I do remember her saying that.
And the court then said, what did she tell you about that? And the juror said, it was after you let us go on the last break. I was very upset. This is what you're talking about. And she came down and talked to me and said that apparently, I don't know who talked to him, but he said he was drunk and he removed the post. Do you recall that?
Well, she didn't tell me that, and I didn't talk with her about that.
Well, you saw that post, the so-called apology post, did you not?
Right, I did.
And you assumed that was a post from her husband, did you not?
Right.
And then you talked to the juror about that, did you not?
I did not talk with the juror about that.
Well, who did you talk to about it? Did you bring it to the judge's attention?
No, we didn't get a chance to talk to the judge about that.
Oh, boy.
Has the clerk discussed anything about the case with anyone on the jury? The juror said, not that I'm aware of. The judge said, okay, she was just discussing with juror. She pulled me aside when we went downstairs after the last break. I want to say it was after lunch, and we came back, and that's when she first told me about it, about this, what we now know was not a post from her husband.
Right.
But you assumed it was a post at the time, and y'all had a conversation about it, correct? Don't just nod. Answer the question.
Yes, sir. Yes, ma'am. I believe that it was one of my staff that she talked to, but it was not me that she talked to.
But the juror says, and I want to say it was after lunch we came back, and that's when she first told me about it. She's talking about you.
Correct.
Then we went back into the court, and I never even got to sit on the jury. The judge says, the judge then stops the questioning, and she exits the room. Mr. Griffin, Your Honor, I think that satisfies it. She hadn't talked to anybody, hadn't expressed an opinion, hadn't made up an opinion. She's got an ex-husband, and she has 3 restraining orders against him. The court said, Mr. Waters, just obviously we're all invested in this. My main concern, I certainly would love to, but not love to, but want to hear, what one of these individuals said. But, she answered the questions as she did, talking about the juror. They then have a colloquy about this juror and whether this was really her husband that put this post in that you talked to her about and apparently talked with the court about at some point. Am I right?
That's right.
So you talked to her at some point. Alec Murdaugh looks like he wants to start yelling things out in court. And I understand how frustrating it would be to sit there as a defendant and look at this woman.
The judge said
saying whatever.
He was not too happy with your having talked to the juror before you talked to him. Do you recall the judge saying that?
Yes, ma'am, I do.
And did you pop right up there and say what you're saying now, that you never talked to her?
Yes.
We never talked about it after that. I wasn't in the room when he said that.
And how did you handle the sealed exhibits in terms of their availability when these press people are there photographing exhibits?
They stayed sealed.
And so you think that you're aware of the fact that some of these on-the-scene photographs of the 2 decedents found their way into the public press. You're aware of that, are you not?
Yes, ma'am, I am. Yes.
And you contend that they photographed him in the courtroom?
That is what I heard.
All right. Finally, you have indicated about your book that
I'm very
some things
surprised
that
how
you
long
put
this
in
is
there
going
were,
on.
you called it literary license, not literally true, correct?
Correct.
This book wasn't a novel, ma'am.
Did you ever, by any kind of email communication or in any way, shape, or form, indicate or state that you wanted a guilty verdict because it would increase the sales of the book? Did you ever say that in an email or verbally or in any other way?
No, ma'am, I did not. It
I did
didn't
not
matter
see any
to
of that
me
in the email either.
if it was guilty, not guilty, or a mistrial.
Well, in your book, you suggest that the guilty verdict was what you wanted, and you were fearful
What was in your emails?
That a guilty verdict would not be rendered. You say that a lot about your feeling about wanting a guilty verdict, do you not?
I do agree that that is said in the book. And,
You
and
wrote
part
the
of that
book.
is
Your Honor, I agree that the book says that. You wrote the book. You wrote the book.
because
Well,
I think
Except for the part you plagiarized.
it was a guilty verdict.
Well, this is that you were describing a time way before the verdict was rendered when you wrote about those things in the book. Isn't that correct?
It is, yes.
And you even have something where you said your eyes met with jurors and others at
Yep,
Moselle,
and we all
y'all have
knew.
an understanding, unspoken, that he was guilty. You said that in the book, did you not?
I did say that in the book, and I would consider that part of the literary, the word that we just said. But there was nothing spoken with a juror at all at Moselle or anywhere else at the courthouse or anywhere. I think that's part of that poetic license that we write to make something more
10-10.
apparent. But at no time did I read or try to read someone else's eyes, and that was just one of those gut feelings that I wrote in the book.
But that's not what you said. Oh, that's not what you said. Sometimes when you get the attention that you seek,
You wrote
you
in
might
the book,
find there's a downside.
speaking of a time before the jury verdict was
This is
rendered.
the downside.
I was conflicted about knowing the Murdaugh family and about having so many people watching and listening to me as I read the verdict. I was mostly concerned about Alex being found innocent when I knew in my heart he was guilty. I had this fear that the goodwill the Murdaughs had built up in the community would influence the jury. You wrote that, did you not?
Yes, ma'am.
So you had those feelings well before the verdict was announced in this case. You had some definite opinions and feelings about what the verdict should be, did you not?
I did have a certain way that I felt.
And
But I would never.
that's not any poetic license, what was said there. That's how you felt, correct?
Correct.
All right.
That's how you felt.
Those are my
Correct.
questions. Anything further from the state, Mr. Waters?
That should be a no.
Now, can I make you one other offer
Yes, sir.
today and today only? Egg Lady is across the street.
Well,
No. If you want to put her on the stand.
No. Your Honor. Just in case you're curious.
I've made my position quite clear about that. I think we've got in the record what is needed in terms of
He's trying.
what she says, Ms. Hill says, and what Ms. Hill says she says.
I said mount up and ride.
I
He's
agree.
trying.
We did not intend on calling her. I just didn't want you to miss the opportunity if you wanted the opportunity to
Your Honor.
examine her.
Thank you, Mr. Harpoot.
I'm just
All right,
being
court will be in
considerate of
recess
what you
until
might want.
3:15.
So let's go back to court after the break. Judge is back on the bench after the break, and we are going to get into the defense impeachment witnesses.
All right, Mr. Harpootlian, I believe it's
Your witness.
you to present your witness.
Yes,
Please be,
Rhonda McElveen.
Rhonda McElveen, clerk of court.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, that's what I'm here for. I'm Texas.
Thank you. Please have a seat on the witness stand. State your full name for the record.
Rhonda McElveen, RHONDA MCELVEEN.
And Ms. McElveen, what do you do for a living?
Clerk of Court and ROD for Barnwell County.
Clerk of court in what?
Register of Deeds. I have 2 titles.
2 titles.
And the registrar of
deeds. Appointed
deeds.
or an elected position?
Elected.
So you're elected by the people of Barnwell County.
Yes, sir.
And how long have you been the clerk of court of Barnwell County?
This is my 16th year.
16 years. And
Yes,
and I'm
sir.
running again, sir.
you're up this year? 24 is?
Yes, sir.
All right. Are there certain rules and constraints that clerks should operate under in terms of dealing with juries?
Yes, sir.
Once that jury is sworn in, what is your role in terms of dealing with those jurors individually or as a group? Are you allowed to talk to them individually, to pull them out, to converse with them about your opinion about the case?
To pull them out of the trial while we're going on?
Yes, ma'am.
No, sir, we're not. If they're on a break, et cetera, or if they request to see someone, then we manage to, I'll go in the door open. I'll say, which one of you needs to see someone? It might be the judge. And I said, hold on. And then I go get my judge. And so we've got a juror that needs to speak with you.
Do you
That's it.
converse with jurors about the merits of the case, by the merits, whether someone's guilty or innocent, or whether a plaintiff or a defendant should win in a civil case? Do you ever do that?
No, sir. About the most only thing I ever do is go in and count them and tell them I can count up to 14 without even using my toes. And then I might get their lunch order. That's it.
Before the trial, before we ever picked a jury, did she ever discuss with you that she was going to write a book?
Yes, sir. She wanted to write a book. Yes,
wanted
sir.
to write a book. Did she indicate what the book was going to be about?
About the trial?
About the Murdaugh trial?
Yes, sir.
And did she discuss with you, what, if anything, did she discuss with you about how she felt the verdict should turn out to be in the Murdaugh trial? Vis-a-vis, in reference to the book, what would help the book?
A guilty verdict.
And tell the judge and me what exactly.
Well, Poot, when you ask close-ended leading questions, the answer is going to necessarily be a yes or no, because you're asking a yes or no question. If you want an open-ended question, just ask her, what did Clerk of Court Becky Hill tell you about what she wanted in this verdict regarding writing a book? Just ask.
She said to you that you remember. This is prior to the trial.
Okay. Well, first of all, she said we might want to write a book because she needed a lake house and I needed to retire. And then
that sounds like a joke.
Further conversations, a guilty verdict would sell more books. And we left it at that. This was before, even in December.
And when did she ever say that again to you during the weeks you spent there?
Several times. It could be said it was, amongst friends in her office, or we might be having dinner, that kind of stuff, but that's about it.
That she needed a guilty verdict to sell more books.
That would be the best way to sell books, yes, sir.
The best way to sell books. Now, during this
I think
process,
a hung verdict would have been the best.
Did she ever express to you an opinion on whether or not, in fact, was Mr. Murdaugh guilty of the murders of his son and his wife?
Yes, sir.
Tell me what she said, and if you remember when.
I don't exactly remember when. I know it's over half of the trial had already happened, but the evidence was coming forth that it looked like he might be guilty, and she made a comment that a guilty verdict would be better for the sale of books.
Okay. Now, as a result of a conversation you had sometime during the trial, I don't want you to relay to me what was told you. Did you have a discussion with the clerk, Becky Hill, about her being with jurors on her own?
Yes, sir, I did. One morning I showed up to Colony County and I was told that she had taken a juror home the night before. And
Who
I
told
was in
you
the
that?
courtroom and I saw her, and it was between the pews and where the back row pews are. And I mentioned to Miss Becky, I said, please tell me you didn't take a juror home last night. And she told me, she says, I did, but I didn't talk about the case. I had a bailiff with me. Mr. Bill was with me. I said, Becky, you don't do things like that. I thought we had stopped everything. It wasn't far enough along to really cause a major problem, or I would have told Judge Newman. But I thought we had an understanding that you did not spend time alone with the jurors.
Okay. Now,
I thought she understood that you don't spend time along with the jurors. I want to know who told her that. Like, how did you hear about this? But, oh gosh.
I'm going to
I want to hear from Mr. Bill
read
too.
you some statements. Well, first of all, did you ever hear her say anything in front of you to a juror about whether or not on the merits of the
polls
case,
at the end of this
that is,
witness's
whether or not he
testimony
was
chat.
guilty or innocent, or what you should pay attention to? Did you ever hear her? What, if anything, did you ever hear her say to a juror or in the presence of a juror? Anything?
No, sir.
Okay. But let me ask you if you've ever heard her say these statements, and if so, to who? Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understand. Do not be fooled by the evidence presented by Mr. Murdaugh's attorneys. You ever hear her say that?
Your Honor, this time I would object. This witness was specifically called as a Rule 16.3b extrinsic evidence. I think we've covered the two grounds
impeachment
that would be permissible for her to testify to, and I believe that should be the.
Oh no, Becky Hill's still in the courtroom. She sure is.
Further extrinsic
Sitting right there, looking at Rhonda.
Improper impeachment and also irrelevant. I think that the issues that were raised with the prior witness have been covered, and that was the express reason that this witness was called, and Your Honor allowed the testimony.
Overruled. You may continue.
Yep.
Did you ever hear her say that?
Can you repeat the verbiage?
Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys.
Yes, I did.
And who was it said to?
It was said to me.
Okay.
And sometimes it might be a staff member in our office or someone from the media there. But other than that, I didn't hear her say it out there in front of any jurors.
Did she ever say to you or to other people around you, I'm not talking about jurors, watch him closely, talking about Mr. Murdaugh. This is just before he testified. Look at his actions. Look at his movements. Did you ever hear her say that?
Yes, sir.
Okay.
Wow.
Did you ever have any conversations with the bailiff, Mr. Bill?
Yes, sir.
Did he ever discuss with you the
This is getting into
court's
hearsay.
contact with jurors?
No, sir.
Okay.
Wow.
Did you ever hear her say that the defense is going to try to confuse the jurors? Did you ever hear her say that?
No, sir, I don't think so.
Okay.
It's not uncommon for, clerk staff behind the scenes, not to the parties, not to the litigants, not to the jurors.
It's not
but
a
among
closing
themselves
statement.
back in, in the hallways back there to talk about the day's activities and things like that. Is that fair?
That's correct.
That is
Okay.
not uncommon.
And that's a big difference between the natural conversations that people that work together, court staff and the like, have with each other and actually having those conversations in front of the jurors, right? There's a big difference between those two, correct?
Yes, sir.
Okay. And it's not uncommon for you. You're a clerk of court. You got people that work for you. Y'all are going to have private conversations about what's going on that are not to be shared, particularly with jurors, but with the public as well. Is that fair to say?
That is true.
Okay. All right. And so there were conversations like that going on that you were privy to and part of. Is that correct?
That is correct.
Okay. All right. And you mentioned a little bit about, well, let me ask you this. So there are all these conversations going on, and that's natural. That happens, private conversations with court staff behind closed doors. But you never once saw or observed or had anyone tell you that any of those conversations were being shared by Miss Becky with any juror. Is that right?
That is correct.
All right. And if that had happened, if you had observed anything
Can we get back to
untoward
the
or
giving somebody
improper
a
going
ride
on in this
home?
particular trial, you would have immediately gone to Judge Newman as part of your obligation. Is that correct?
That is correct.
And you never did that because you never observed anything like that. Is that correct?
That is correct.
Okay.
I've got a lot of questions about giving this juror a ride home, But remember this morning, a juror was asked about that and a juror said, no, I never got a ride home. So was Becky taking a literary license to make herself seem more involved in this case than she was? I don't know. I really don't with that point. But the clerk of court from Barnwell, Rhonda, heard that Becky gave a juror a ride home with Mr. Bill.
Half a question.
All right.
Mr. Waters indicated to you that you were not aware of whether or not, and you agreed that you never witnessed her talking to a juror about the evidence. Is that correct? We agree on that. Do you know, but she did admit to you that she had been with a juror alone in a car for some period of time when you confronted her with that. Is that
Thank
correct?
you for circling
Yes,
back.
sir.
And did she indicate to you what she talked to that juror about while they were alone in the car?
No, sir. She told me, the only thing she told me was that she did not discuss the case, that she had Mr. Bill, the bailiff, with her, and he could tell her that. Tell that.
But the juror said they didn't get a ride home.
When she said she didn't discuss the case, did you bring that up or did she bring that up?
She brought that up.
You didn't say shouldn't be with him because it's
improper,
frowned upon?
I did tell her that I would caution her on doing that because the perception of dealing with the jurors one-on-one is not tolerated.
The appearance of impropriety is hard to overcome. Yikes.
Thank you, Ms. McElveen. You may be excused.
After a very long day in court in South Carolina, Justice Toal has taken this case under consideration and will be ruling from the bench now as to whether Alec Murdaugh gets a new trial. This is after hearing from all 12 deliberating jurors, one alternating juror, and clerk of court Becky Hill, as well as clerk of court Rhonda, who contradicted some of Ms. Hill's testimony. Everyone deserves a fair trial. The judge is going to rule based on the standard that she has set forth, whether or not a juror's verdict was prejudiced. It's going to, either way, this can be appealed. Either way, the appellate court is going to take up this issue. But I'm very curious to see if she will grant Alec Murdaugh a new trial. And that's what we're here for right now. Alec's got to be nervous as hell. Are y'all nervous?
In the matter of the state of South Carolina against Richard Alexander Murdaugh, the following constitutes my ruling on this matter from the bench. This case is unique in my 20 years of experience as a lawyer and my 35 years of experience as an active justice of the Supreme Court and a senior active trial appellate judge.
This case
usually
is
matters
bananas.
involving possible improper contact with or conduct of a juror arise during or shortly after the trial. The judge then puts the affected juror or jurors under oath, conducts an examination, and rules on the request for a new trial or a mistrial. In this case, I was appointed almost 9 months after the trial to replace the trial judge who was recused. It is now almost 10 months after the verdict was rendered and sentence imposed in this matter. It is now on appeal to the Court of Appeals. Several months after the appeal was filed, the defendant moved that his appeal be suspended and this matter be remanded to the trial court to consider his motion for a new trial on a charge that the clerk of court for Colleton County
I can check the volume.
Jury by expressing her opinion to the jurors about what their verdict should be and about the credibility of the defendant who had elected to take the stand and testify on his own behalf.
He's got to be nervous.
My ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the clerk of court, Rebecca Hill, to a juror or jurors, and 2, prejudice suffered by the defendant, specifically that the Hill improper comments
that Hill's improper comments influenced the juror.
Influenced the juror to vote to convict defendant Murdaugh. The facts. Did clerk of court Hill make comments to any juror which expressed her opinion of what the verdict would be. Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the clerk of court is not completely credible as a witness.
I agree.
Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the clerk of court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified.
This is prong one.
To at least one and maybe more jurors.
She finds prong one to be true.
Did clerk of court
is what
Hill's
she's finding.
Comments have any impact on the verdict of the jury?
This is the prong that matters.
I find that the answer to this question is no.
No new
Each
trial.
member of this jury took their involuntary assignment very serious.
No new trial.
They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task.
This will be
11
appealed.
of the jurors very unconditionally said they either heard no comment or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous affidavit in which she said the effect, if any, that she had was pressure she felt from other jurors. The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations.
That's correct.
But the juror who was somewhat ambivalent said on her oath at the time of trial twice and said on her oath before me in these proceedings that she stood to her oath.
Okay.
The clerk of court allowed public attention of the moment to overcome her duty.
Wow.
I have read the entire transcript of this lengthy trial, not an easy task.
Damn.
I have studied in detail all of the authorities cited.
I mean, you came prepared.
I have independently researched the case law, learned treatises, and scholarly articles on the subject. Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity-influenced clerk of court.
Wow.
This is a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find
foolish and fleeting comments
for a new trial on the factual record before me must be denied, and it is so ordered. I will file a fuller order which denies this motion on the grounds I have recited.
He is going to appeal this
on
ruling,
the record before me,
and his appeal will click
judge,
back into
and the authorities
action.
that have been cited by all parties in this matter. I have probably had more experience with trial and appellate work than anyone else in this room.
Yes.
For many years.
Agreed.
And it has been an absolute pleasure to receive from these learned lawyers some of the best briefs I've ever received. I know they're a product not just of the attorneys who presented to me, but of the attorneys who sit with them and help compose the
learned
research
lawyers
and the writings that I received. I know that I put you on a very tight timeline.
Yep.
But my feeling is that these matters are best disposed of by the trial judge in a very timely manner, so that you may then go to the authorities that really count more than I do. That is, the appellate authorities who will decide what the standard in this particular matter is.
Because this is going on
I've not seen
appeal.
a case such as this before. I doubt whether our appellate judges have seen a case such as this before. And they will take a lengthy time to study the record in this matter, the record in the part remanded to me. There are many issues in this case, issues over which I have absolutely no authority whatsoever. But I will say this about the record now that I have read it. And I will say this about the testimony that I heard Friday and today. Judge Newman said it best in his sentencing when he discussed the weight and the measure of the case presented and testimony and evidence submitted in this case when it was tried. It is a very compelling case supporting the verdict that the jurors reached. He said it with a lot more detail than I do, but now that I've read the record, I say as the successor trial judge, I agree that the evidence was overwhelming and the jury
got it right.
Not surprising. This matter is now adjourned.
Explain to us how you found out this information.
We found out the information by talking to the jurors. You heard the alternate testify today, and honestly, that was really the first one-on-one interview that we were able to get. We had gotten some indications from lawyers who represented some other jurors that we needed to go down this road, and when we finally met with
Jim, are you saying that lawyers that represented jurors said you need to find out what's going on with the jury? Is there more to this?
Her as she's cooking Sunday dinner in her home down a dirt road. I mean, she told us things that were jaw-dropping, and so that's how we found out.
And would there be a different outcome if you get another trial?
I didn't hear the question.
Yes, there would be. But I'm not going to tell you why.
Absolutely, yes.
You all have said that you're investigating who might have actually committed these murders.
Yes.
Have you all found anything that you think you want to share with us?
We have developed some information. We want to get this behind us, and we'll be pursuing that in the near future.
More. They have more.
Who really did it?
Do you believe Alec Murdaugh has it?
I'm sorry. What did you just say, Dick Harpootlian? Dick Harpootlian says we are developing new information of who really did it. That's exactly what he just said out of his mouth at this press conference.
Do you believe Alec Murdaugh has information? Because his voice is not familiar. Do you think he has information about who did it?
Well, if he did, we couldn't tell you. That's called attorney-client privilege. I can't think about what my client could have told me. That would be attorney-client privilege. These rules are so pesky. You get credit.